Mr. Fernandez kept his foot up for 30 seconds. I'm taking these long pauses for a reason. Even though he just said, I don't remember my training, I still got him to admit, I'm sorry, what? What? Well, hello everybody, and welcome back to your favorite show on the internet, Raw Law Unfiltered, with your favorite host of all time, the DY Guy. Plus, today we are going to continue on the cliffhanger that we left you off with last time. I am about to tell the jury in our Officer Oliver cross-examination. Once again, the players are me, Officer Oliver on the stand. We have Lee Wilson, the prosecutor. We have the jury, my client and my associate on the back, and to my right is the judge. I am about to demonstrate what 30 seconds feels like. Let's go. By the way, some of you, for the record, I've been reading your comments, and thank you every single one of you for commenting on this new series, because I want to know how it's going. How are you feeling about it? So far, it's been nothing but positive, with one caveat. Some of you don't know how to read the description below, it seems like, because literally the very first line of the description is, if you want to see the full video without any interruptions, just click the link. Because some of the comments were like, this guy talks too much. I just want to hear the cop's testimony, by God. The link is in the description below, dog. Just click on it. And you can watch the whole testimony, the full 58 minutes. Direct examination, cross-examination, without any interruptions by this guy. The whole purpose of this series is for you to not just watch it. If you want to watch it, please continue. The whole purpose is for you to watch it with commentary. A lot of you are not lawyers. A lot of you are not judges. A lot of you are not prosecutors. You don't know what I'm doing and why I'm doing it, and I'm breaking it down. This is a teaching experience, and I hope you all are enjoying it. From the looks of it, most of you are. So thank you very much for all your likes and comments and subscriptions. I'm starting the timer right now. Now, the mistake, again, that I think in hindsight I could have done better is I could have stood on one foot to show them during those 30 seconds what 30 seconds feels like on one foot. Instead, I'm just letting them feel what 30 seconds feels like. It would have made it much better difference. It would have been a much great. Look at how uncomfortable Mr. Wilson is getting. He doesn't know what to do. It's 30 seconds of silence, and it's my case. He doesn't know what to do. He's getting very uncomfortable. I should have kept my foot up during those 30 seconds to emphasize Mr. Fernandez kept his foot up for 30 seconds, and he didn't hop, he didn't sway, he didn't put his foot down. Okay, so he put his hands 6 inches away from his body. So what? The point is being made. Again, look at Juror in the yellow shirt. He's just got his hand up to his... He's getting suspicious about this officer already. According to my stopwatch, that's 30 seconds. May I approach, Your Honor?
Okay.
Does that read 30 seconds, officer? Always confirm. Never let the jury take your word for it. Always confirm with your witness. Why? Because he's not your friend. And if he's agreeing with you, that means it's fact, because he will do everything to not agree with you if he can, or she, if your witness is a female. They will do everything in their power to not agree with you. And if they're agreeing with you, that means it's fact, because then they would disagree. So for that duration, the only clue you saw, Mr. Fernandez, is he used his arms for balance. Correct?
Correct.
And there it is. The hammer with respect to the one-leg stand. During those 30 seconds, the only clue you saw was he used his arms for balance. Again, ideally, you would want to repeat. So he did not put his foot down. Correct. He did not sway. Correct. He did not hop. Correct. For emphasis, the choice is yours. You don't have to do it, but it will definitely make your case stronger if you do. And then take a sip of water. You're not in a hurry. Let the officer marinate. My favorite word. Marinate him. Next, you did the walk and turn, correct?
Yes.
Do you remember the clues and how many there are on the walk and turn?
No.
Boom! He knows what's coming. Do you remember the clues? No. Do you know how many? No. I asked him a compound question. I should have broken it down in hindsight, but again, hindsight 2020. But I didn't even get a hesitation there. He's just like, I don't remember, dude. I'm not even going to fight you on it. You've already proven your mettle, mettle. You've proven your mettle previously with me during the horizontal gaze nystagmus, which again is a made-up term, and the one-leg stand. On the walk and turn, do you remember the clues now? Do you remember how many there are? I have no idea. He's literally just admitting, like, I don't know, which is exactly where you want your officer to be if that's a fact. I mean, some officers are very highly trained and they're very knowledgeable, and sometimes they will polish up and remember what the clues are before they come in to testify. Not this one.
So you don't remember that the National Highway Traffic and Safety Administration, in their manual, they outline specifically 8 clues that you're supposed to be looking for?
I can't recall exactly what the manual says, no.
You just got him to admit that he does not remember his training. Doesn't get much better than this, folks. Again, I'm taking these long pauses for a reason. I am letting now the jury soak in what he just said, because it takes a moment. You listen, you hear it, you understand it, you process it. Now you're sitting with it as a juror. Never spend a single second during your cross-examination that is not conducive, that does not benefit you or your client or your case in some way, shape, or form. Do not, under any circumstances, ask silly questions or stupid questions or questions that are not getting you anywhere. Because first of all, the prosecutor will eventually object. The judge will definitely sustain that objection. Your jurors will hate you for wasting their time and not being respectful of their time. So long as you're accomplishing some goal, your jurors will love you for teaching them something new.
You are aware that there are 8 clues, correct?
Even though he just said, I don't remember my training, I still got him to admit, you are aware that there are 8 clues. And he's probably searching in his brain going, I might as well not argue with this guy. Yes, correct.
One of them is when the suspect can't keep their balance during the instruction phase. Does that ring a bell?
Yes.
Starting too soon is number 2. Stops while walking. Does not touch heel to toe. Steps off the line.
Now, the reason I'm going through these one by one is because I was given a very unique opportunity. I got a chance to teach the jurors something that the cop should have taught them. And by God, I am taking that opportunity because now they understand that this is a thing. This is a real thing. And he doesn't know. I'm not even waiting for him to answer now because he is embarrassed. I don't want to give him an opportunity to try and snake his way out of this one. I have complete control. I am simply reading them, and he gets to sit there and listen to what he should have known at the beginning of this trial.
Using arms for balance, performing an improper turn, and taking an incorrect number of steps. Does any of those ring a bell?
Yes.
Would that be a fair assessment from your memory based on what I just said, that those are the 8 clues?
Yes.
Always get him to confirm because they don't know. You might be reading from a pie recipe book for all they know. Obviously, it's a little exaggerated, but you understand what I'm trying to say. Once he admits that, oh yes, I do. These do sound familiar. I don't remember them from my training, but now that you mention them, you know what? They do ring a vague bell. Well, now you've shown that the officer doesn't know the clues. He doesn't remember them. He knows they exist. You just read them. And yeah, they sound familiar. So those are the 8 clues. Mission accomplished. Moving on.
So based on your investigation, you did note that Mr. Fernandez used his arms for balance. And then you also note that he lost his balance on the first step, although it's not one of the clues. So he exhibited 1 clue, right? And pursuant to your training by the National Highway Traffic and Safety Administration, having 1 clue is not indicative that an individual is under the influence of alcohol, correct?
Well, I mean, that's not necessarily true.
Again, he's trying to weasel his way out. Watch what he does.
Might be what it says, but it's not necessarily true.
So
He's trying to escape his training. He's trying to pull wool over your eyes and the jurors' eyes. That basically my training, the way that I'm trained on standardized field sobriety tests, doesn't matter. I create my own assessment as a police officer on the side of the road. Mind you, there is no video in this case, so you are completely and utterly dependent on his testimony, both on direct examination and on cross-examination. So you have to pick his case apart at its constituent parts, which is what I'm doing here. The thing that I was unprepared for is to have such a bloody weasel in the witness stand who is literally going to say that, you know what, my training doesn't matter. And you're about to see what he says.
The training is wrong?
I deal with individuals.
Right there.
I mean, the clues and what it says is, what it says is what it says, but, if what I deal with all the time, there can be individuals that show different patterns of everything. I've had individuals that have come back to the jail and blown 3 times the legal limit that could walk and talk just as well as me and you. So to say that, that he wasn't under the influence just because he showed one clue, I can't really say that.
He just contradicted his training in a very sneaky way. I have had individuals who blow triple the legal limit and still do phenomenally on standardized field sobriety tests. First of all, that is a lie. Secondly, he again is not answering your question. He's evading your question. So your job is to reel him back in. You are not following your training. You literally just openly admitted that your training says one thing and you do something completely different based on just what, personal experience? If this had been a different county, like a bigger county, like Jefferson County, this would be an automatic not guilty. 100%. Because unfortunately, in the bigger counties, you're more likely to get more educated, more well-versed, more worldly jurors. In smaller counties, sometimes even the best cases can be lost simply because the jurors have a hunch that your client maybe was under the influence. And no matter how much you try to hammer that beyond a reasonable doubt standard, they're always going to default back to, well, he seems like he was drunk, so I am going to assume the cop was right and I'm just going to use a much lower standard than beyond a reasonable doubt and still convict your client. But I'm not going to give them any jail time. I'm going to split the baby. Jurors do this all the time, and I've seen it way too often. They will split the baby. They'll convict, but no jail time, minimum fine, minimum everything. But we're just scared to let them go because we don't know. Well, I don't know means not guilty. And no matter how many times I've tried to hammer that into the jurors' minds, sometimes I am lucky to have had experience trying cases in very, very small counties where some of my jurors have a 6th grade, 8th grade, if I'm lucky, 10th grade education. And they've been working for maybe the last 20, 30 years in some industry. They're handymen. They are very capable individuals, but they don't understand what the court and I are asking them to do. They always default to their own personal experiences. I'll give you an example. Horror story time. This is LaRue County, Kentucky in 2020, February. I am trying a case before Judge Reed. Judge Reed is on the bench and Kyle Williamson, I believe, was the prosecutor. I have a female who's my client and she is about 8 months pregnant. Just so happened she didn't plan for that. I know how some people will plan for an individual to be pregnant during trial. This was not our plan. It just coincided. She was moving along with her life. EMS professional. And the jury, I had a phenomenal closing prepared for them. My entire jury, I believe, had a maximum of a 12th grade education, or 10th or 12th. I can't remember exactly how far they got. All 6 of them. I had their juror qualification sheet, so I knew. And it was terrifying after they came back guilty, no jail time. I asked them why or how, after this should have been a slam dunk anywhere else in the state. This was one of my first real realizations 4.5 years ago of how carefully I have to tread with jurors who may not be of the same level of education as I would like them to be. And I had one master's degree in theology juror in the potential pool, and Kyle Williamson struck him because he knew that if we have a simple jury with a basic human understanding and nothing more, they don't have as much worldliness, it's a lot easier for him to convict, because jurors who don't really venture outside of their own world, they don't have a worldly experience. And again, I'm not hating on them, but I would prefer they weren't on my jury, because these are not the jurors that I am looking for my jury in order to understand the intricacies of the law and to acquit my client. That's just the way it works. You have no idea how racist, sexist and misogynistic and misandristic jury selection can be. You should hear some of the conversations that myself and one of my associates have behind closed doors when we are picking our jury. Newsflash, that's normal. Good lawyers, excellent lawyers, amazing lawyers do exactly that. Why? Because that is how you pick the perfect jury. Read some of Clarence Darrow, the magician of the 20th century. Clarence Darrow is by far the number one best criminal defense attorney of the 20th century. No arguments. I don't think anybody can argue otherwise. Jerry Spence in the civil arena and Clarence Darrow in the criminal arena. I would be so lucky to be called the best trial lawyer of the 21st century next to Clarence Darrow. I don't know if I will ever get there or if I even have the aspiration anymore as I am doing other things. But let me tell you something. Clarence Darrow wrote an entire manual on how to pick a jury, what sort of jurors. And he talks about the Irish. He talks about Catholics. He talks about Protestants. He talks about very, very, very like religious-based, race-based concepts like African Americans, whites, Hispanics, Irish. It's normal during jury selection. So anyway, with that out of the way, here's what happened. My 6-person jury with a 12th grade maximum education comes back guilty, no jail time. And I asked them, after court, after they render their verdict, I'm sitting there or standing there and I'm talking to them and I'm like, if you guys don't mind, I just want to ask you a few questions. They're like, yeah, sure. And I said, why did you convict? Like, what went sideways? Like in my head going, I thought this was a slam dunk. Why did you convict her? And I swear, my hand to God, the 4-person looks at me and he takes his glasses off and he goes, well, and I'm going to use made up names. John over there had a cousin. And he's pointing to one of the jurors. And he said, John's cousin had a very similar case to your client's. Very similar fact pattern. We talked about it in the deliberation room. Hold on a second. Did you just admit that you ignored the evidence? Did you just admit that you didn't listen to anything I said? Did you just admit that you didn't care about what happened in this case? That you were talking about John's cousin's case and comparing it to my client's? Okay, do go on. And he went on and he said that John's cousin had a very similar fact pattern to my client in LaRue County, Kentucky, and he ended up pleading guilty. He never took it to trial. What does that have to do with my case? What does that have to do with my client's case? She's not John's cousin. She is client. Okay, and why did you convict? Well, he goes on, because John's cousin pled guilty, because he thought he was guilty, we thought she was guilty too. It's the same fact pattern. I almost fainted when I heard that. I could not believe that I just lost the case because someone's cousin had a similar fact pattern to my clients and they ended up in the back room and that's all they talked about because they came back within like 10, 12 minutes. Juries are fickle. I would try a case in Lexington, which is Fayette County, or Jefferson County, which is Louisville, any day of the week, simply because we get better jurors who are more worldly, they understand things more, they are willing to hold the government to their burden. Unfortunately, in a lot of these smaller counties, people trust their government. People love their government. People love their police officers. Sometimes the complete opposite is true if there is a lot of corruption that is rampant. But it is just one of those things that nothing can prepare you for the type of responses that you get. I had another jury. Here's another war story for you all. Muhlenberg County now. We're close to the Red River Gorge. We're about 45 minutes northeast of the Red River Gorge, where a lot of people, including myself, have gone rock climbing in years past. Here, the facts actually matter because of what you're about to find out. My client is driving from Tennessee to his home in Pike County. Now, if you're not from Kentucky, you may go, wait a second, how did he end up in Muhlenberg if he was coming from Tennessee to go to Pike County? Because Tennessee is right here. So he was coming from the border right near south of Middlesboro, Tennessee. I believe it was Middlesboro. And he was traveling to Pike County, which is over here. Okay, Pike County is over here and Tennessee is over here. Muhlenberg is all the way over here. So how was he going to do like a fish hook loop or something? Here's the problem. His phone dies and his GPS is gone. So now he has to rely on his sense of direction. And it's very foggy that night. Long story short, ends up getting pulled over and arrested for DUI. At trial, he testifies that he did not have his charger with him, his phone died, and he lost his GPS signal and his ability to GPS his way, and that's why he ended up where he was, but he refused the test, therefore he was not guilty. There was no evidence, there wasn't enough evidence, I should say, of intoxication. That video, by the way, is on my channel. At least the cross-examination I know is. Well, At the end of the trial, I talked to the jurors, and unbeknownst to me, there was a Karen on my jury. You know what a Karen is? A Karen is an individual who wants to speak to the manager anytime they're not happy, right? That's the kind of person I'm talking about. And again, I hate to give labels to people, but she was just straight up a Karen. Why did I say that? Why do I say that? Because of the following statement that she told me. She was the foreperson. And I asked them at the end of the trial, why did you convict? They split the baby. Guilty, no jail time. And I asked her, why did you convict? Now, during the trial, 2 police officers testified, and then my client and his brother. She said, and I quote, "Your client is about the same age as my son, somewhere between 21 and 22 years old. My son would have never forgotten his charger. That's how I knew that your client was lying." I'm sorry, what? What? Lady, you do realize that my client and your son are not the same person. They're not even in the same universe. And yet you convicted because you thought he was lying about forgetting his charger. Because your son would have never forgotten his charger. Therefore, guilty. True story, folks. You never know what a jury is going to do. Thank you all for joining me. Thank you all for watching. I love every single one of you. By the way, did I tell you all? We're on a new schedule. Every day, new video, 6 p.m., no exceptions. Raw, law, unfiltered, with your favorite host, the DUI Guy Plus, signing off. Bye, everybody.